Get your legal questions ready because coming up next is Live and Legal with attorney Mary L. Yancey. Good day. You are Live and Legal with attorney Yancey. I'm looking forward to sharing and talking with you about the law, those legal matters that mean the most to you and are affecting your lives. Please know that our brief conversations do not create a lawyer-client relationship, nor does it call for confidentiality, but my office is always available for further discussions. So, let's get live and legal. Good day, everyone. You are now live and legal with attorney Mary L. Yancey. It's so good to be back with you all. I trust that God is blessing all of you all in this new year of 2016. So today, everyone, I want to share with you some information regarding probate law. Some of you may remember in previous shows, we've talked about criminal law and we've talked about family law. Today, I want to share with you some things about probate law. Again, as you know, I practice family and criminal law primarily. Probate law is a form or a part of family law, and that's what I would like to speak about today. And remember, if you all would like to call in, you can call at 248-796-8241. That number is 248-796-8241. And as always, if you'd like to speak with me offline, you can contact me at the law office of Mary L. Yancey. I'm located right next door to the Penobscot building. I am in the Ford building, and that address is 615 Griswold Street, Suite 510, and that's right in your downtown Detroit. So let's get started. Probate court, probate law. As most of you all know, we have what is called or what is recognized as Wayne County Probate Court. There are several things that go on in our probate court, and that is located in the KMAC building, the Coleman A. Young Municipal Center on 2 Woodward. Each county, as you know or may not know, has their own probate court. Ours is located here downtown Detroit. Several things go on in probate court, and we want to address those things. A lot of things that probate court deals with, some things happen before death, some things happen after death, and some things happen regarding estates that are created after death. Let's start off with, what are some of the reasons you might find yourself in probate court? Well, probate court deals with two issues that I think may be familiar with you all, that you may be familiar with. It deals with conservatorships and it deals with guardianships. A guardianship is almost, and I'll put it in layman's term, a guardianship, when you have guardianship over a person, it typically means almost that you are their parent. You take care of the needs of that individual. And the reason why you have petitioned the court in order to obtain guardianship is because there's some reason why that individual cannot take care of themselves. Oftentimes, we as family members find ourselves stepping or filling the shoes of a family member that has passed along. Sometimes our family members and our loved ones leave children upon their passing. And you may find yourself having to come to the probate court and obtaining guardianship over them. That allows you basically to take care of their everyday life. Oftentimes they're children, and of course if they're under the age of 18, 21, they can't take care of themselves. So therefore you would have to petition the court for guardianship over that individual. What does that mean? That means that you basically take care of all the needs and necessities of that individual, the same way their parent would take care of them. That may or may not mean including, but not limited to, making sure that they have their daily necessities. That means a roof over their head, adequate fooding, adequate clothing. making sure a child goes to school every day. And as you know, you need guardianship papers because you won't be able to if you don't have that authority from the courts. Oftentimes, schools, medical facilities, hospitals will not give you the information that you need in order to make sure that that minor child is being taken care of. So that's how the probate court can assist you in that. And then oftentimes when you take on the task of raising someone else's child or raising your family member who may have suffered a loss, you also have to maintain and you have to manage their finances. Oftentimes, when you take on that responsibility, some type of financial benefit or financial stipend is attached to that individual. Well, in that case, we suggest that you go and you become and you petition the court to be conservator of that individual's. And again, the purpose of obtaining those papers would be because that individual, for whatever reason, is not able to take care and adequately and sufficiently take care of their financial needs. So therefore, and you may be familiar with this term, you pretty much become a payee of that individual. If that individual is receiving some type of benefit because of their loss, you would become their payee. Now, therefore, you would be responsible for those funds for that individual. Now, when you petition the court, especially, well, in addition, if the individual is a minor, when you petition a court to become a guardian or a conservator, that attaches additional responsibility. Since the court is now involved, you have to report to the court because, again, the court's main objective is to look out for the welfare of that individual. Not necessarily you, but to look out for the welfare of the individual because you have solicited the courts saying this person, and this is a legal term the court uses, this person is a protected individual. So therefore you have to account for the things that you are doing on behalf of that individual. As a guardian, we have what are called annual reports regarding the minor child or the protected individual. And as a matter of fact, to make sure you're living up to your responsibilities, the court will even send out special individuals, oftentimes in the person of an attorney. They will send those individuals out to the home where the protected individual is staying to make sure that the home is clean, the home is neat. They'll have a brief conversation with the ward, as we call them, to make sure they're happy, make sure they believe that their needs are being met, make sure they don't think that they are being taken advantage of. So the court also sends out individuals to monitor your activities and monitor to make sure that you are taking care of the responsibilities that the court has entrusted to you. When you request to be conservator of an individual, that means you're taking care of the finances for that individual. Oftentimes, when family members find themselves in that situation, it's not always easy to make sure that the finances that this protected individual is receiving, all of those funds are to be spent on that individual. That would simply mean that even though that check is coming in your name, because you're doing it on behalf of the individual as a fiduciary to that individual, you have to give account for how those funds are being utilized. That is done also on a yearly basis, sometimes even less frequent than that, but typically on a yearly basis. The court is entrusting those funds to you. So therefore, in that case, every year you have to file what is called an accounting. And what an accounting tells the court is how much money that individual has received or that you have received on behalf of the individual. It talks about how those funds were spent. It tells the date that those funds were spent. It tells the individuals, the third parties, who may or may not have been instrumental in caring for that individual. For instance, you may have a caretaker come into the home to help. There may be things in a child's life, a reason why other individuals have to be involved in their life. Maybe a therapist, maybe doctor bills. Whatever the area that you spend these funds in, you have to give account for that with the court. Now, sometimes the court will not require a hearing, will not require a more in depth explanation as to how you spent the funds, and sometimes they will not. So you have to always be prepared to show the court how those funds were spent and why. And in the event that a special circumstance arises, you can always feel free to petition the court to maybe purchase something specific for the individual that may not have been in the original instruction as to how you are to utilize those funds. Now, let's talk about what happens after the death. After the death, most of you all know what a power of attorney is. For those of you who do not, a power of attorney is a document that gives individuals the authority to work on your behalf. So, for instance, if for whatever reason I am not able to take care of my finances or to run errands that may be necessary, I can give someone the power of attorney over me. And that document basically gives them the authority to be me. So in whatever area that I would be able to make decisions on my own behalf, my power of attorney has that ability to do the same thing. And of course, as you know, a power of attorney's authority and rights can be taken away just as easy as they were given. They can be taken away at any time by the individual who first submitted them. That is going to be significant before death, but after death, once a person passes away, that power of attorney, that authority passes away with that individual. At that time, it is what is called as a representative or an executor of that estate. So once a person passes, they have what the courts call an estate. That means that it involves whatever assets, property, or finances that individual has prior to their death and at the time of their death. All of those things in a nutshell, or they all become in a package what we call the estate. What's important about all of these things, and I would suggest it to anyone who is listening, prepare a will. Oftentimes, I hear people say, we want to avoid probate. We want to avoid having to probate our loved one's estate. We want things to be taken care of prior to their death. So this is what I suggest that you do. First and foremost, you prepare a will. Now you may say, I don't have any assets. I don't have tons of money. I don't have thousands and thousands of dollars. So why do I need a will? You need a will simply because you would like to diminish the possibility of friction in the family. Most of you all, and I'm sure all of you all, have experienced the death of a loved one. And sometimes it seems like even though we're all family, we're of the same bloodline, we lose our minds when we have family members who go on. And if they have a little bit of assets, oftentimes it causes contention between your siblings and your loved ones. A will oftentimes can help you avoid those problems. A will is simply going to tell the executor or the representative who you will name in the will, who you want to handle your business after you pass away. Oftentimes, if you do this, if this is done prior to death, that means you get the chance to discuss it with your family members. So then when you pass away, and again, it doesn't matter what age you are, because as we all know, tomorrow is not promised to us. So regardless of what age you are, you get a chance to sit down with your family and your loved ones, and you get a chance to tell them what you want done specifically, who you want to do thus and so. And that way, when you pass away, no one can say they didn't know. No one can feel ostracized, or no one can feel that they are surprised by your wishes. Within that will, you should consider depicting and delineating who you want to execute the will, who you want to make things happen. You need to consider who you would like to leave your assets to. Now, those assets could be bank accounts, insurance policies, and oftentimes an insurance policy usually isn't part of an estate because an insurance policy is a contract. And prior to death, when you take on an insurance policy, usually that company will ask you, who do you want the beneficiary to be? So because you designate that beneficiary before your death, that won't even become a part of your estate. That's a contract. And upon your death, that company will immediately contact your beneficiary. Family doesn't have to get involved. They deal with that individual specifically and alone. However, some of the things you may want to consider delineating who do you want to take these items. For instance, it could be something as little as a watch. It could be something as little as earrings. It could be the furniture in your home. It could be the electronics in your home. Whatever type of asset. It could be your car. It could be your truck. It could be anything. It could be your fur coat. But these are things that oftentimes family members find themselves fighting over. And of course, it's your goal to make things as smooth and easy as you can for your family upon your passing. So after you have determined who you want to leave these things to, that is what you put in your will. And then you just simply take your will down to the probate court and they file it for you. So upon your death, it will already be there. Now, in addition to taking it to the probate court, you should also give a copy to each and every beneficiary that you have named in your will. And that way, upon your death, they're not scrummaging around trying to find your will because everything is already organized and stated in your will how you want things to be done. Now, there are a few things that you can do outside of your will to make even the will that you do write or draft. It will have as minimal amount of clauses as possible to make it small as possible. What you can do is, before you pass away, have someone else on your checking account with you. There are some items that you can take care of prior to your death and prior to your writing a will. If you put someone on your checking account with you, upon your death, that person is automatically going to be the beneficiary of those funds. Sounds easy? It is easy. And I would suggest that that be done. How many of you all can testify to the fact that one of your loved ones has passed away and you knew they had an account at a bank? So you went to the bank to try to get those funds out of that account because your loved one had passed away, especially if you need those funds to pay for the funeral expenses. And the bank says, sorry, those funds are now a part of that individual's estate. Well, that's because there wasn't a second person on the account. There's also a way that you can do it. If you don't feel comfortable putting a person on the account with you, the banks often have a process called payable upon death, a POD designation. You can simply contact your bank and have them put your loved one's or your friend's name as the person to make those funds payable upon your death. That way, none of those assets end up in the hand of the probate court or in the pot of your estate. That will be taken care of. No arguments, no fights. It's taken care of. Another asset that oftentimes is left when someone passes away is the home, the house, the home that the loved one lives in. There's a way you can take care of that also, so that the home doesn't become part of the estate. Simply put someone on the deed with you. Upon your death, if you pass away, that person who you have on the deed with you becomes the owner of that home. It doesn't have to be probated. It doesn't have to be argued about in court. It doesn't have to be argued about when your family is sitting around the table trying to plan for your final arrangements. It's done. And the family will know, because you've done this prior to your death, this was definitely your wish. How many times have we found ourselves planning a funeral and we're arguing over that wasn't mama's desire, that wasn't what daddy wanted to do? Well, if you take care of these things before your passing, that could cut down on a lot of contention between your family members. Now, let's talk about some frequently asked questions. Now, let me direct you to the Wayne County Probate Court's website. That website is http://wcpc.us/info/info, that's info/info .html number 2. Or you can simply go to wcpc.us, and then you can guide your way through the website that way. That's a little simpler. wcpc.us. On that page, they have a lot of information. I encourage you to go to it because you can actually read and you can get even more information than I'm sharing with you today. You can read for yourself. You can click on those issues that matter the most to you and that are pertinent for the time that you are searching the website. Now, the website has on it a listing of frequently asked questions. Let's go over a few of those. The first on the list is administering a decedent's estate. And we've talked a little bit about that. If you should find yourself having to probate your loved one's account or your loved one's estate, you go down to probate court. Now, again, this question often comes up. Do I need an attorney to do that? I would definitely suggest that you get an attorney to do that for you, because it's one thing about probate court matters. They are inundated with paperwork and documents and forms that must be filled out meticulously and completely. Sometimes it's much easier to simply hire an attorney to do that for you because they're used to doing it. They're used to the process. They're used to the people down there. And one thing that the Wayne County Probate Court makes very clear is that their representatives and clerks are not allowed to give legal advice. So if you don't understand how to fill out a form and it turns out to be an actual legal question, you're going to find yourself running into a wall because they aren't allowed to grant legal advice. Can you imagine that? Because then they would be held liable for anything that they do wrong. If you hire an attorney, I think that will afford you the peace of mind that you have someone that is knowledgeable about the process as well as the environment of the probate court, so you can rest. And that's important at a sensitive time, such as during the death of a loved one. That allows you to grieve, and then you let someone else handle the business part of that situation. So you hire an attorney, and if you should find yourself having to do it yourself, you come down to the court. And probate court in Wayne County is located on the 12th and the 13th floor of the Coleman A. Young Municipal Center. You go to the 13th floor to actually file the documents and to get the forms, and you tell them what you want, and they will briefly tell you what you should do. For instance, guiding you to the correct document to get. But as far as giving you actual legal advice, what you should do here, you should do there, what's expected of you, some of those things are legal questions. And again, they are not allowed to give you that information. That's where it all starts. You get the documentation. You take the documentation home. You collect the documents of your loved one, such as the death certificate, any insurance policies that may have been out there. You find out where their assets were being held, whether it be a bank, whether it be a safe deposit box, wherever their assets are. You're going to gather all those things, And as representative of the estate, you will file what is called an inventory. And you have to list all of those things, all of those assets that your loved one held at the time of their death. In addition to that, there's a responsibility to involve all of the other heirs of that individual. And see, it's already sounding complicated. And again, that's why I would definitely suggest that you hire a legal professional to assist you in that matter. But at some point, you're going to have to, in administering the estate, you're going to have to file an inventory and tell the court, this is what my loved one had as assets at the time of his or her death. After you have done that, then you have to what we call serve the other heirs or the interested parties. So that means sisters, brothers. It may mean cousins, aunts, uncles, grandparents, or just parents. It could involve, depending on your situation, a plethora of individuals who you have to keep informed as to how you are administering this estate. After you do that, hopefully a will was done. And if it winds up in probate anyway, you will then have the responsibility to administer and distribute each of those assets the way your loved one has requested, whether personally to you or whether in writing in their will. You will then be responsible to, after all of that is done, you will also be responsible to paying any bills that may be still outstanding of your loved ones, the loved one that has passed away. So there are a lot of responsibilities in administering someone's estate. And that is all the more reason why, again, I would suggest that you do hire a legal professional, an attorney, in order to make sure that that is done expeditiously and proper. Because trust me, you will save yourself a lot of heartache and contention probably with the family members if you should decide to do that. Okay? I don't want to talk your ear off, so I'm going to give both of us or all of us a little bit of a break. We're going to have some music for a little while, and then I'm going to come back and we're going to continue our conversation regarding Wayne County Probate Court. Thank you.
With our hands high, we'll just sing that again. Hosanna. Hosanna. Sing it again. Hosanna, say Hosanna in the highest, and our King. Say Hosanna. sing it again to you. Where else can I go? Oh, 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 where else can I go? I'm gonna follow you, follow you. Where else can I go?
Hello again. You're live and legal with attorney Mary L. Yancey. Welcome back. And again, if you want to call in and ask some questions, or even after the show, if you want to ask questions, you can reach us at 248-796-8241. That number again is 248-796-8241. And of course, as you know, you are listening to Worship Center Radio. Okay, let's continue with the probate court answers. While you all were gone, I received a couple of questions based upon what I had already said. One of those questions was, how do I get my loved one's financial assets from the bank once they have passed away? If the name of the child or the sibling of the deceased person, if their name was not on their checking account, how do I get those funds? Well, whoever was named as the representative at the time of the death of the individual, you're going to go to probate court and ask the court, and this is how you open up the estate. Once you open up the estate, they're going to give you what are called letters of authority. And that is the document that you will have to take to the bank or any establishment or any agency that is holding your loved ones, the deceased person's assets. If they are holding something in your loved one's name, that is the document that you need to take to them in order to have access to those funds. Now, when you get those funds, you're not getting those funds as my son John or my daughter Mary. You're getting those funds as the representative of the estate of Jane Doe, your loved one, the person who has passed away. So therefore, you just can't spend the money as you would like. Those funds are to be distributed and utilized per the law, per the person's will, and per the interest of the estate. That would mean once you receive letters of authority, it is your responsibility to go to the bank or any other financial institution and open up an account called the estate of Jane Doe, the deceased individual, and then that account will also have your name on it. But again, you're no longer my son, my daughter. You are my representative. You are the fiduciary of your loved one's estate. So therefore, those funds have to be utilized accordingly. Those funds may be utilized in paying for the funeral expenses, paying the taxes, the outstanding taxes of the individual that has passed away, paying any debt of the individual who has passed away. So again, once you receive letters of authority, that is when you can go and access the funds on behalf of the estate, not on behalf of yourself. I also received a question about how assets are distributed. Are they all distributed evenly? Are they distributed 50%, 40%? Well, that would depend on the loved one's prior wishes that has passed away. That's the important part of writing a will before you pass away. If you draft a will before you pass away, you have the liberty of distributing and delineating your assets any type of ratio that you would like. You could say, I want all of my assets to be sold, my house, my car, my clothing, my jewelry, and I want my 3 sons to split it evenly. Or you could say, I want my home to be sold. I want 20% to go to my niece. I want 20% to go to my nephew. Or you could say, I just want everything liquidated and I want it to go to this one person. Or I want everything liquidated and I want the representative to decide how he wants or he feels best that my assets should be distributed. So again, if you take the time to plan prior to your death, you can distribute your estate any type of way that you want. Now, if you fail to do that, then the court is obligated to do it by law. And most of the time, and I'll try to keep this in layman's terms, most of the time in that case is going to be done equally. However, it's going to be done equally based upon your relationship with the decedent, with the person that passed. For instance, if the person that passed had a spouse, more than likely the complete estate may go to the spouse, and then it's up to the spouse to distribute the way they feel is in the best interest of the family. And then if there is no spouse and there are children, then those assets are going to be divided between the children, and it's going to be done evenly. So if there are 4 children, then that would mean that each child would get 25%. And then there's the possibility of maybe the decedent's child is deceased, but they left heirs. They have children. So the decedent, the deceased person, has grandchildren. So therefore, the grandchildren will have to be factored in. So therefore, thereby you have how things can get real complicated. That's why it's so important to actually draft a will. And that way, a judge in a black robe who doesn't know your family, knows nothing about you, they don't get to decide how your estate is divided. You can take control of that prior to your passing away. So let's get back to the frequently asked questions at the probate court. One of the questions that they have that are frequently asked, they state that a lot of times people can't determine the difference between child custody versus the guardianship of a minor. Well, I briefly talked about the guardianship of a minor earlier in the program, so I just want to briefly talk about the differences. Child custody matters are done usually by the biological parents of that child. Excuse me. The guardianship of a minor child can be petitioned by almost anybody. Anybody who believes that it is in the child's best interest that they become their guardian. And usually the only reason why a guardian would be needed is if the child's parents were not in the picture for whatever reason. They could be deceased, they could be in the hospital, just simply they don't have the wherewithal, nor the will, nor the capacity to be able to parent the child in the proper way. So therefore, someone else other than their biological parent will probably step up. Maybe an aunt, maybe an uncle, maybe a sibling will step up and say, hey, I would like to have guardianship of my minor niece, nephew, or sibling. In that case, the court will, of course, go through the normal process one, to make sure that it is in the child's best interest. Two, make sure that individual is able and equipped to be that guardian. And again, don't forget, you're going to have to notice everyone who would be what we call an interested person in the welfare of that minor child. And then oftentimes, people get confused about child support. Remember, child support only applies to the biological parents of the minor child. Now, should you become guardian over a minor child who does have living parents or parent, then yes, that parent may still be obligated to pay child support on behalf of that child. Again, I would suggest that you consult an attorney because they can tell you the difference in the two and then tell you how you would go about to make that happen. Okay? Some of the other things, frequently asked questions. Money due from a decedent's employer, wages and fringe benefits. Oftentimes when a loved one passes away, we do find ourselves having to contact their place of employment to find out about what they had, what were their assets upon their death. Well, again, remember I talked about those contracts that don't become a part of the estate. Usually when an individual has assets or benefits through their job, they will have already designated who they want to be the beneficiary of that asset. For instance, an employee and a loved one works for General Motors and they have, say, a 401k plan or an investment plan. More than likely, the employer has already required that that individual designate a beneficiary upon their death. Usually it's a spouse. If it's not a spouse, then that individual, that employee, will have already designated someone else other than a spouse, a loved one, a child, etc., etc. They will have designated who they want to be the beneficiary of that benefit upon their death. Now, if that beneficiary was not designated, then that would become part of the estate. Okay? Remember, and that's why it's so, we've heard the cliche, if you fail to plan, plan to fail. That's why it's so important that you draft, that you think about, that you discuss with your family. You discuss all these things prior to your death, and that really, really helps. That helps the family. That diminishes the amount of contention that the family is going to have because they already know what your desires are. Okay, and then let's pick another frequently asked question. Obtaining your own will filed with the court. That's another benefit. If you have drafted your own will prior to your death, when it is time for your transition, then your family can simply go to the court and say, hey, here is mom and dad's will, and therefore that makes life much easier for your family. Again, I wanted to go back to the issue of power of attorney because I wanted to talk about the two particular different kinds. Now, there's one power of attorney that people use to cover finances. That means whoever your designated power of attorney is, they can feel free to manage your funds, to make any type of business decision or financial decision that you will have on your own behalf. They have that authority to do that. Okay? But then there's also a power of attorney that is called an health advocate power of attorney. That means you have designated a particular individual and then they have a successor advocate or power of attorney that will take the place of the first one if they are unable to perform their duties as power of attorney health advocate. Now, that individual will have the ability and the authority to speak on your behalf in the event you are incapacitated in the hospital, if you are in a coma, if you are basically just physically or mentally unable to make your decisions. Now, again, the importance of planning. In that power of attorney for health advocate, you're going to designate your wishes. For instance, oftentimes we find ourselves in the position where we have to determine whether or not we want to keep our loved one on life support. That's the purpose of the power of attorney health advocate. In the event that you are unable to relay to the doctors this is your wish, you will have already given that information and told your loved one, your power of attorney health advocate, what you desire. No, I don't desire to be kept alive by a machine. No, I don't desire to be kept alive if I have to be fed through a tube. Those type of specific wishes are actually placed within your power of attorney health advocate so that when that time comes, you don't have to worry about your family disagreeing on whether or not they want to keep you alive by extraordinary means. It makes life a lot easier for your family, especially at that sensitive time of your transition. Sale of real estate. Now let's deal with that. Again, it's so important. If you write out a will, your family will already know what your desires are. If you do have assets, particular assets in the form of real estate, then your family will already know mom and dad have chosen to sell this. And then upon the selling, then they will distribute those proceeds according to your will, according to your desire. Fees, that's one thing you should know. Every petition, every particular area in the probate court that you're going to petition the court for, whether it be guardianship, whether it be conservatorship, whether it be adoption, whether it be pleadings in order to determine how to distribute assets, whatever it is, please note that there are fees. Please be prepared. Now, you can do that by going onto the Wayne County Probate Court's website. They actually delineate the fees for each and every petition that you may find yourself having to file with the probate court. So be prepared to pay fees. But blessedly, they aren't astronomical. The fees are pretty reasonable, and you don't have to worry about it being out of your budget. And for those who it may be out of your budget, I do believe that there are avenues where the court will assist you and ultimately simply waive those fees for you if you meet a certain standard based upon their policies and procedures. Another frequently asked question. It talks about juvenile court questions. Now, please be aware that juvenile court usually deals with abuse and neglect of children or the adverse actions of children. So those issues are taken care of separately from the probate court. But do remember, even as a guardian, you don't have to be the biological parent of that individual. But if you're the guardian of that minor, then you will be responsible, or you will be expected to handle those juvenile matters in juvenile court. We also received a question, and we'll make this our last question of the day. We received a question regarding court-appointed lawyers to be the representative and or executors of estates. Oftentimes, the court does have that ability to do that. The court also has the ability and authority to appoint what we call as a GAL, a guardian ad litem. Those are individuals who are non-associated with the family, so therefore they have a bit of a preference because they don't have a dog in the fight, as we would call it. They more than likely they don't have an ulterior motive. They can strictly act on behalf of that individual. Well, the court often uses court-appointed representatives, executors, or guardian ad litems to make sure that protected individual, that minor, that incapacitated individual, to make sure his wishes are fulfilled, as well as to make sure his assets are efficiently and sufficiently and appropriately administered and utilized as they should, as they ought to be. One area where the court often does this is if there is the assets, there's a considerable estate wherein they don't want the family to misuse the funds or basically kill each other over trying to get their hands on the assets. Oftentimes the court will appoint what is called a special conservator to take care of that, so you won't run into those problems. But yes, the court does use representatives, court-appointed GALs, to make sure that your family members' wishes have been kept and that their funds and their assets have been appropriately utilized. And that keeps, again, contention down in the family, and that makes everything smoother, so that during that time your family can grieve appropriately, and they can go on loving one another after the passing away of your loved one. So thank you all. I have enjoyed speaking with you today. It's good to be back. Remember, if you want to give us a call, even after the show is over, you can reach us at 248-796-8241. And also remember, you have been Live and Legal with Attorney Mary Yancey. I am located here in the city of Detroit. My address is 615 Griswold, Suite 510. I am right next, Detroit, Michigan, 48226. I am right next door to the Penobscot building. Most of you all know that building of the Friend of the Court building, the child support building. Real easy to find. You don't like going there, but you know where it is. So thank you again, everyone. God bless. I trust that God is continuing to bless all of you in this new year, 2016. I invite all of you all to join me in great expectations of what God has in store for us. Remember that He loves us. He loves us beyond measure, so much so that He died for us. And I thank the Lord for all of you all listening. I hope that I have been a blessing to you all. And again, let's look for God to do some amazing things in 2016. According to your faith, be it unto you. See you next time. Thank you for being Live and Legal with Attorney Yancey today. I want to thank all of my friends and sponsors for their continual support. The law firm is located right here in the D, 615 Griswold, Suite 510, 48226. God bless, and I look forward to being Live and Legal with you next week.